The appellant herein,
जी
namely Kasida Khatun,
जी
is around 80 years old woman at present.
जी
Kindly have a look the arrest memo which I annexed with my application
जी
in year 2016.
पैरा 11 में डीडी है मेरे
In
हाँ?
year 2000,
पैरा 11 डीडी है इसके खिलाफ में।
अच्छा हाँ देख लेते हैं क्या से डीडी
kindly see the arrest memo with my
Okay.
application. Annexure A2. In year 2016, she was 72 years old.
ठीक है ठीक देख रहे हैं देखें सर डीडी क्या है हाँ हाँ, नहीं वो तो ठीक है नहीं वो ठीक है लेकिन डीडी तो देख रहे हैं सर मैरिट पे कुछ बन रहा है इनका तो डीडी इज एग्जिबिट
डीडी इज द एग्जिबिट माय लॉर्ड। EW1 is the witness, my lord. DD exhibit. छोड़ दो क्या डीडी का एग्जिबिट क्या है?
Exhibit है P1. Exhibit P1.
E1 है
Supported by the extra electron.
E1 है।
जी पढ़िएगा डॉक्टर कौन है
मतलब in fact, your lordship, the doctor who conducted the postmortem, the doctor who has given the
डॉक्टर हु हैड सर्टिफाइड
मतलब he has not been examined
ही हैज नॉट बीन एग्जामिन्ड
because that
जी
Christopher was not examined. And the doctor who conducted the earlier MLC was not also examined. Pre-MLC जो हुआ, there is a more than 90% burn injury, and it is also evident from the postmortem report. Fingers जो है, हाथों की गदेरियां सब भी लगी हुई।
किसकी गवाही पढ़ रहे हैं
PW19.
एक सेकंड PW19. Dr. Suryakant.
पैरा 3 में इट इज आस्क्ड, मैं रीड मतलब,
हाँ पढ़िए।
ये कहना सही है कि मृतका के पैर और सीना छोड़कर शरीर का पूरा हिस्सा जला हुआ था, अकड़न आ गई थी, मृतका के दोनों हाथों के पंजे और उंगलियां भी जली हुई थी, अकड़ गई थी। यह सही है कि जिसके हाथ जल गए हों, जल जाएं तथा उंगलियां अकड़ जाएं, उसके बाद हाथों से कुछ लिखा नहीं जा सकता।
हाँ। जी बताइएगा इसके बाद क्या करना है। सिग्नेचर कैसे आ गया डीडी पर?
The doctor has also examined.
There are two circumstances which you are required to explain. One is signature on DD, and another is that the author, that is executive magistrate, says that he is not remembering whether the family members were present or not. That means that whether the witness was tutored or was under some influence or was giving independent opinion. Coupled with the fact that PW17 says उसने स्वयं जल गई थी,
जी।
ठीक है, and she is the nurse who had taken care of the person at the time of admission. इन तीन सर्कमस्टांसेस का क्या करेंगे? लिखाएं
जी।
अपील फाइनली
बेल में काइंडली कंसीडर।
बेल तो कंसीडर हो जाएगी, इसको उसके बाद बचा क्या है इसमें? जितनी देर में वो लिखाएंगे उतनी देर में।
ठीक।
या तो इसको सर 8 साल हो गए, उसको वन कर दें, या तो कहीं एक होटल दिखाना है, सोच चलिए। उसकी चिंता नहीं, लिखिएगा। This appeal is filed. With the consent of the parties, appeal is heard finally. Next, this appeal is filed being aggrieved of judgment dated 4/1/2020, passed by learned Sessions Judge Chhatarpur in Sessions case number 225 of 2016, whereby sole appellant Kasida Khatun, wife of Mumtaz alias Katu Khan, has been convicted under Section 302 IPC with life imprisonment and fine of ₹500 with default stipulation of 1 month RI. Next pair. It is submitted that appellant is innocent. She has been falsely implicated. Next pair. Reading from the evidence of PW17. Praful Kumar Arnist, son of late Shri Noble Arnist, staff nurse, Mission Hospital, Chhatarpur. It is pointed out that this witness was working as male staff nurse at Mission Hospital, Chhatarpur. Full stop. The doctor who had treated the deceased, namely Dr. Christopher, is in America taking treatment. Full stop. It is mentioned in the examination in chief that Dr. Joel had examined the deceased injured at the Mission Hospital, Chhatarpur, when she was brought by Javed Khan. Full stop. On examination, that she had sustained burn injuries on her own. Full stop. These burn injuries were sustained due to kerosene oil. Full stop. There were 90% burns, including her head, front portion of face, back of the chest, both the hands, both the eyes, private parts, pelvis, etc. Full stop. She was referred to higher center. Full stop. It is mentioned that Dr. Joel had given injury report exhibit P18 as per the directions of Dr. Christopher. Full stop. In cross-examination, she admitted that Dr. Christopher had not signed on Exhibit P1, full stop. She categorically stated that signatures mentioned on dying declaration Exhibit P1 from Sir to Sir and D to the are not of Dr. Christopher. Thereafter, she further deposed that the nature of injury was such that injured was not in a position to write or sign on the document. Next para. This fact is corroborated by PW19 Dr. Surikant Gupta, medical officer who had conducted postmortem on the disease along with assisting Dr. Dinesh Kori, full stop. In para 3, this doctor has clearly mentioned that the person whose hands are burnt, so burnt, will not be able to write, full stop. Thus, placing reliance on these documents, it is submitted that firstly, the dying declaration Exhibit P1 loses its authenticity as deposed by PW17 that it does not contain signatures of Dr. Christopher on the who had given a certificate that patient was in the state of giving was in a proper state to give statements, and then at the end of the dying declaration had certified that the patient was fully conscious while giving deposition. Next pair.
कुछ अच्छा है पैसा नहीं चाहिए राहुल शर्मा को दिन अभी आगे बात है मत शेयर करो ये हाथ पटा तो शायद नहीं सब कुछ मिला अब उसके बाद फिर बस है कि फंड full stop. It has also come on record. The next pair. It has also come on record that PW9 Constable Brij Gopal Ahirwar in cross-examination admitted that the injured Akila had not only burnt both her hands but even her tongue was burnt. Full stop. Thus, the whole dying declaration becomes suspicious, and on basis of such material, it is submitted that conviction solely on the basis of dying declaration is not a safe conviction, and appellant is liable to be the impugned judgment is liable to be set aside and appellant be discharged. Next, Shri Ajay Shukla, learned public prosecutor in his turn, supports the judgment and submits that there is a dying declaration. Author of the dying declaration, that is the Nayab Tehsildar Shri Sanjay Garg, was examined as PW1. In his cross-examination, nothing substantial contradiction has come on record. Full stop. It is submitted that though it was suggested to him that the dying declaration is false, but there is no material to suspect the dying declaration, and therefore conviction recorded on the basis of dying declaration cannot be faulted with. Next paragraph. After hearing learned counsel for the parties and going through the record, अब इसके आगे मैं जजमेंट लगा के लिखा दूंगा. अपील इज अलाउड.
Grateful Lordship.